My name is Jeff Morgan. I am from Dallas, Texas. I'm going to continue on with this article that was written about the man suing to stop no-fault divorce in Texas. And I am that man who's suing to stop no-fault divorce in Texas. I have sent a constitutional challenge to the Attorney General. I've also CC'd the Speaker of the House, the President of the Senate, Lieutenant Governor Dan Patrick, and also the Speaker of the House Pro Tem. So this has gone forward, and I also have filed a motion to dismiss in the court, 301 District Court in Dallas, Texas. There is a motion to dismiss. I think it's actually 30 pages, not 31. I think it's a 30-page motion to dismiss. 11 reasons why this case should be dismissed, because the statute itself is unconstitutional. And what I'm seeking is declaratory relief, not just for me, but for the entire class of people who may be subject to this, quote, no-fault divorce insupportability statute. It's not just a religious liberty issue, though it is that. It's not just a due process issue, it is that. It's the whole thing is that the statute never should have been written to begin with. And we actually have a dissent by a justice back in 2001, Kem Thompson Frost, who said there is no possible way to reconcile 6.001 with Texas jurisprudence. It is unconstitutional. And I want to thank Justice Kem Thompson Frost with regard to that, because actually she laid the groundwork for some of the stuff that we've been working on. When I say we, there's different people that have been working on the no-fault divorce issue for at least 10, 11 years, and people before me. We're taking what others have done ahead of us, and we're trying to build upon those arguments, and I think actually make the case stronger. So the next section of this article says discrimination and same protection as in same-sex unions. So in 2015, the landmark Obergefell v. Hodges decision, the Supreme Court held that denying same-sex couples access to marriage denied them, quote, a constellation of benefits. So when you get married on a federal level, you have benefits based on your status, over 1,000. I think it's over 1,100 benefits. There's one lady out of South Carolina who says that, I thought she said it, 1,151 or something like that benefits that you get at a federal level, not to mention the benefits that you get at a state level. So how can we deny two people who love each other these benefits simply because they're the same sex? Even though our Texas Constitution does define marriage as being the union of a man and a woman, there is no such thing as same-sex marriage according to our Texas Constitution. And I could get into that later on too. But what Justice Kennedy argued, said, how can we deny this constellation of benefits to people that want to be married simply because they're of the same sex? What I want to know then is this: how can you take these benefits away from me when I have committed no civil violation and when I have done nothing that would allow the government to act in this manner? Some of these benefits that are given to two married people are health care, parental rights, property rights, inheritance rights, and other things along those lines. And there's, like I said, over 1,100 such benefits at a federal level, more at a state level. Forced divorce, divorce on demand, divorce for any reason or no reason, divorce against which there is no defense, a predetermined outcome against me, would deny me the right to these benefits that we are now saying same-sex people should have. Does not my marriage, my marital status, merit the same protection as we have granted to same-sex couples? Now, my motion also alleges the violation of due process and equal protection clauses of the 14th Amendment. Specifically, Morgan maintains that the Texas law denies his right to be heard and defend himself. I can be heard in a superficial sort of way, but not in a substantive sort of way. If I can not defend my lawsuit, there is a predetermined outcome. That is the essence of due process, that I should be able to defend myself against a lawsuit. What other lawsuit is there that you go into the lawsuit and it's predetermined? Maybe under Saddam Hussein's Iraq or some other places like that. Maybe under some communist country where they give you we're going to let them speak before we shoot them and kill them and hang them and everything else. That's what's going on here in Texas with the divorce law. I should have the ability to present my case to be heard, meaningfully heard, and the judge should have the ability to deny the divorce based on the allegations that were made, if they prove to be false. And by the way, in my case, no allegations were made. So what am I even defending myself against? There is no triable issue of fact The judge has nothing to weigh. Did he do this? Did he breach this duty? Did he not do this? It just claims to be insupportable. Insupportability is a conclusion of law. Now, we also have in 6.002 cruelty, and it says cruelty such that the marriage becomes insupportable. Now, cruelty, there are specific actions that you could say they've done this, they've done this, they've done this. Therefore, the marriage is insupportable. There are facts that have to be weighed to come to the insupportable conclusion. 6.001 in the Texas Family Code says, without regard to fault. We don't need any facts. We don't need any facts to have a marriage declared insupportable. Simply one person in his or her subjective state of mind, for whatever reason, for no reason, they can make up a reason and claim a marriage is insupportable, and that's it. So by guaranteeing that my wife and all plaintiff spouses always win, and the defendant spouses, people who do not want the divorce to go through, who just say, wait a minute, our marriage is not insupportable, our marriage can achieve all the legitimate ends of the marital relationship, I will always lose based on the way the statute is written and the way that it's implemented in our courts. So the law further discriminates between the parties. And Beverly Willett, a former lawyer, said this, as a lawyer, I think he's right. In addition to these issues that I'd mentioned right here, I also claim the violation of my free speech rights under the First Amendment, contending that the law constitutes viewpoint discrimination. What is viewpoint discrimination? Viewpoint discrimination is when one person says this, another person says that, and the court says, well, we believe this person right over here. So anytime a person alleges insupportability, that is the viewpoint that always wins. The plaintiff will say, our marriage has become insupportable. I, as a respondent, can say it's not insupportable. It can achieve the legitimate ends of the marital relationship. I will always lose. In other words, this is viewpoint discrimination. The state has a predetermined viewpoint that it endorses. The endorsement is for insupportability. Now, really, if the public policy of the state should be to see strong marriages, strong families, and everything else. So even by putting insupportability into the statute, that in itself should violate the public policy of the state. If one person says, no, I disagree, I think our marriage is very well supportable, I think the legitimate ends of the marriage can be achieved, and all we have to do is a few things, the state should give the benefit of the person, just by public policy, to the person who's saying it's not insupportable. The person who is wanting to say that the marriage should be dissolved because it's insupportable should present facts that can be weighed and the evidence accepted. In other words, in this instance, it adopts my wife's views about the marriage and it suppresses my viewpoint. But that's how our nationwide system of unilateral divorce was designed to work. And I've talked with people about this, and they've said specifically, as long as you say and write the magic words, you're going to get your divorce. This is what I told Beverly. No matter what my viewpoint is to the contrary, no matter what facts I may gather, no matter how many witnesses I may have, it will never be heard. It will always be disregarded by the court. The court will always grant divorce on the assertion, the allegation of insupportability. It continues further and says the bulk of his other attacks assert violation of various Texas laws protecting religious liberty and rights of conscience. By the way, the rights of conscience actually is in our Texas Constitution. It's Article 1, Section 6, the Bill of Rights, freedom to worship. All men have a natural and indefeasible right to worship Almighty God according to the dictates of their own conscience. No man shall be compelled to attend, erect, or support any place of worship or maintain any ministry against his content. No human authority ought, in any case whatever, to control or interfere with the rights of conscience in matters of religion. To me, this is a very important issue. I don't believe in no-fault divorce. Jesus talked against no-fault divorce. God said when he created man and woman, he said, for this cause a man shall leave his father and mother and cleave to his wife, and the two shall become one. And Jesus said further, what God has joined together, let no man take asunder. Let no divorce court, let no attorney, let nobody tear this asunder. This is something that God created. Marriage, it was supposed to be holy. This is my religious belief. This is the only way that I would get married, that there would be no divorce ever contemplated between us. Of course, there may be divorce for cause, but reconciliation should always be sought first. But this no-fault divorce, this insupportability stuff, that was very clear before I married my wife. In fact, she sent me a prenup the day before we were supposed to get married, and I took a look at it and I just said, I can't sign this. I will not sign this. It violates my conscience. I will not put myself under the Texas law because my actions are governed by the law of God. And if you want me to sign this, we have a problem for tomorrow. And I was told, well, just go ahead and sign it. We'll throw it in the back of the cabinet. I said, no, I'm not signing this. I am not signing this. It violates my conscience. My prenuptial was that I would never get divorced. I took a covenant and I made a vow to God. And that should be stronger than any type of prenuptial. The government tries to invalidate prenuptials on many occasions, but a vow to God in my religious conscience, and my wife made the exact same vow to God, this should not be permitted by the state to actually break that. No human authority, whether it's a judge, whether it is a divorce attorney, whatever, in any case whatever, ought to interfere with the rights of conscience in matters of religion. And to me, my marriage was a matter of religion. In addition to the rights of conscience, there is also the Texas Religious Freedom Restoration Act, and this is codified in the Texas Government Code 1110.003. Religious freedom is protected. A, subject to subsection B, a government agency may not substantially burden a person's free exercise of religion. My free exercise includes my ability not only to get married, but to stay married, to fulfill my biblical obligations to my wife, to please God, and to conduct my marital life in such a manner that pleases Him. I also, as a Christian, say that marriage represents the relationship between Christ and the church. This is something very important. Marriage to me is a sacrament of the church. It's a sacrament that is holy before God. In fact, this is something that that Catholics and I believe Orthodox as well agree to. In the Protestant churches, we generally don't see that. We say there's two sacraments. There's baptism and there is the Lord's Supper. I go to a church that has a third sacrament. It's the sacrament of marriage. And I've been looking for that in Protestant churches. Marriage is a sacrament of God. It's a symbol of God. So therefore, subsection A does not apply if the government agency demonstrates that the application of the burden of the person is a furtherance of a compelling governmental interest. So the government has to show me how divorcing me against my will, against my consent, when I protest and say our marriage is completely legitimate and is valid and can achieve the legitimate ends, what is the compelling government interest that they would force divorce upon me and change my marital status, cause me to lose these federal and state benefits simply because, well, there's a judge that says we should do this. And it also has to be the least restrictive means of furthering that interest. So even if it can compel a governmental interest, it must be the least restrictive means of furthering that interest. And I will tell you, there are many least restrictive means other than a forced divorce. So anyway, Morgan believes that marriage is permanent. Absolutely, I do. It's supposed to be the symbol of Christ's love to the church. That's what it portrays. And if marriage can be destroyed, it's almost as if Christ can abandon the church. By being forced to divorce, however, the law prevents him from fulfilling my biblical obligations, my biblical duties, to maintain the marriage covenant. So I'm going to continue on with this article. There's two more sections here. And again, I'm saying that this is an issue of constitutional importance, something that should not even be permitted in Texas. Once again, facially, it is completely unconstitutional. We've been brainwashed into believing that this insupportability clause is somehow okay. It's not okay. I'm fighting this on the basis of the Constitution and protections for all people that enter into the marital relationship before God, and even for those who don't. Again, I also solicit your prayers for me and for my wife, because this divorce should never be taking place, and I'm going to be challenging the statute that would enable this. And I'd like the Attorney General or whomever it needs to be, I don't know who we're going to have to sue to get this in place, But this is a constitutional challenge to Texas Family Code Statute 6.001. Thank you.